The subject of my speech is control of external migration in the light of international standards. As a general rule, international law doesn't regulate the issue of foreigners' access to the territory of a state. In particular, it does not contain a general legal obligations according to which a state should enter foreigners into its territory. No general international norm, either customary or treaty-based, has developed in this regard. International practice quite generally accepts that states have the power to limit and even deny access to their territory for foreigners. However, this power is subject to the limitations imposed by international agreements concluded by the state. These treaties are, of course, diverse in their nature, but for the purposes of today's speech, I will divide them into several categories. First of all, treaties regulating the status of foreigners, in particular, the 1951 Treaty on the Status of Refugees. But I would also include in this group readmission treaties, especially concluded by European Union with another states. The second group is treaties liberalizing the movement of person. For example, agreements liberalizing or abolishing visa requirements or agreements on procedural simplification in the visa procedures. The third group is agreements establishing international organization within which the communitarization of asylum and migration policy has taken place. And especially European Union is an example of this kind of organization. And the fourth group are treaties establishing mechanisms for protection of human rights. A shape of a state's power to regulate foreigners' access to its territory is also influenced by customary international law. Suffices it to say that the principle of non-refoulement now has its basis in customary international law, but also diplomatic asylum also has its legal basis in rules of customary law. During my speech, I would like to focus on standards related to border crossing that have been developed in treaties establishing international human rights mechanisms. These treaties deal with the issues of crossing state borders by foreigners in a fragmentary manner. Agreements in the field of human rights have, in principle, regulated the so-called internal migration. It means migration in a situation where a foreigner has already legally entered the territory of a state of which he or she is not a national. According to Article 12 of the International Covenant on Civil and Political Rights, every person is entitled to freedom of movement and settlement within the borders of any state, and to leave any country, including its own, and to return to his country. A similar regulation is adopted in the Inter-American Convention on Human Rights in Article 22, and in the African Charter on Human and People's Rights in Article 12. In European area, these rights derived from especially Protocol number 4 to the European Convention on Human Rights, and it is Article 2. But the European Convention on Human Rights also prohibits the collective expulsion of aliens in Protocol 4 and regulates procedural guarantees for the expulsion of aliens in Protocol number 7. However, the real revolution in the power of states to control their own borders has been made by the jurisprudence of the bodies established under human rights treaties, in particular by the European Court of Human Rights. The European Court has extended many human rights to migrants and to foreigners, and regulated their status by referring to human rights such as the right to life, Article 2, the prohibition of torture, Article 3, respect for private and family life in Article 8, or freedom of religion and belief in Article 10. Cases before the European Court of Human Rights related to illegal border crossing have shaped a rather broad understanding of the scope of the European Convention. According to Article 1 of the European Convention, states shall secure to everyone within their jurisdiction the rights and freedoms set out in the European Convention. Under the European Convention, a state's jurisdiction is essentially territorial and is exercised over the entire territory of state. It means land territory, sea territory, and air territory, of course. The principle of territoriality creates a presumption that acts of the state performed outside its territory do not give rise to liability under the European Convention. But in the Banovic case, the European Court of Human Rights emphasized that a state will only incur liability for acts performed outside the state territory if there is a jurisdictional link between a person outside the state's territory and the state's conduct. In determining whether such jurisdictional connection exists, the European Court refers to international law, especially to principle of nationality or the principle of flag in the sea law. The massive influx of migrants into Europe after 2015 have given rise to European Court jurisprudence related to the jurisdiction of a state over migrants at the state's border. The European Court of Human Rights has been confronted with the issue of whether a migrant at a state border crossing is under the jurisdiction of the state's authorities. A state border is a surface separating different types of the state territories. It is neither a strip of land separating two states nor a line. This means that some border facilities, such as border crossing checkpoints, for example, are located on one side of the border and in fact constitute the state territory. For the European Court of Human Rights, it is sufficient that the events which took place at a border checkpoint located at the border with a neighboring state operated by the relevant border guard units of that state. As a result, the presumption of state jurisdiction applies to all actions taken in these checkpoints. European Court of Human Rights jurisprudence has developed also a few rules related to foreigners' access to the territory of a state other than the state of their nationality. First of all, the European Court does not statute a general right for a foreigner to enter the territory of a state other than his or her nationality, nor does it grant them a right to international protection, such as territorial asylum or refugee status or another international protection. When deciding to leave their country of residence, a foreigner is only free to go to a state to which they can be admitted in accordance with its domestic law, nor does the European Convention oblige states to grant visas to foreigners. Secondly, the European Court of Human Rights did not question the admissibility of the criminalization in national law of illegal border crossing or illegal stay on the territory of the host state. Thirdly, the Protocol number 4 to the European Convention prohibits all collective expulsion of foreigners. An expulsion is collective in nature if it concerns a group of foreigners who are forced to leave the country and does not extend to situation where such a measure is taken on the basis of a reasonable and objective examination of the specific case of each foreigner in the group. The fact that a number of foreigners are subject to similar expulsion decisions does not in itself lead to the conclusion that there is a collective expulsion, as long as each person concerned is given the opportunity to present arguments against his or her expulsion to the competent authorities. Fourthly, a foreigner may be deprived of his or her liberty in order to prevent illegal entry into the territory of the state, or if deportation proceeding is pending against him or her. The deprivation of liberty in each case should be carried out in the procedure established by the law and in accordance with the law. And fifthly, Protocol number 7 to the Convention, of course, regulates the procedural guarantees for the expulsion of foreigners. A foreigner legally residing on the territory of any state may not be expelled from the territory except as a result of a decision taken in accordance with the national law, and should be able to first submit reasons against expulsion, second, to have his case reviewed, and third, to be represented for those purposes before a competent authority. A foreigner may be expelled without the above rights if this is necessary for reasons of public order or justify on grounds of state security. It is worth emphasizing that these guarantees apply only to a foreigner who is legally present on the territory of the state concerned. Therefore, if the foreigner's visa or residence permit has expired, he or she does not benefit from the protection afforded by the Protocol number 7. It would also appear that foreigners who have arrived at an airport or seaport but have not yet undergone migration control or have been admitted to the territory solely for the purpose of transit or for a limited period of time for a purpose other than residence do not benefit from the guarantees flowing from this provision. Because due to lack of time, maybe I will stop my presentation at this moment. Of course, I am open for all questions, and I try to answer all of your questions. Thank you very much.